everyone, welcome back to our channel Law Point. This is Reenu Thomas, your host for this episode. In a landmark move, our Parliament has enacted significant changes to the nation's criminal laws, including the Indian Penal Code, the Indian Evidence Act, and Criminal Procedure Code. These reforms, effective from July 1st, 2024, are very essential for us to understand, as ignorance of the law is not an excuse. So join us as we delve into the details of these prominent new laws and its potential impact on our society. We have with us Mrs. Praseena Elizabeth Joseph, advocate on record from the Supreme Court of India, to explain the same. So let's watch this episode.
Indian Penal Code, Code of Criminal Procedure, Indian Evidence Act are regarded as the heart and soul of Indian criminal legal system. Indian Penal Code defining what constitutes a criminal offence and what should be the punishment. For example, what constitutes murder, what constitutes theft, and what should be the punishment for murder, what should be the punishment for theft, etc. Then there is Code of Criminal Procedure prescribing the procedure for investigation and trial of offences in court. And Indian Evidence Act detailing out how evidence need to be collected and used in trial in the court. Together, these three criminal legislations forms the basis of Indian criminal justice system. However, if you closely look at these legislations, these were all introduced in the colonial era. Indian Penal Code is passed in the year 1860, around 164 years back. Indian Evidence Act was passed in the year 1872, around 152 years back. And the Code of Criminal Procedure was passed, the latest one was passed in the year 1973. Though these legislations were updated to cope up with time, the Parliament felt the need to modify the Indian criminal justice system. As a result, Parliament passed three new legislations and they received the assent of the President on 25th December 2023. These three criminal legislations came into effect on 1st of July 2024. These three legislations are Bharatiya Nyaya Sanhita replaced Indian Penal Code, Bharatiya Nagarik Suraksha Sanhita replaced Code of Criminal Procedure, and Bharatiya Sakshya Adhiniyam replaced Indian Evidence Act. Now let's see what is the meaning of these three legislations. Bharatiya Nyaya Sanhita. Bharatiya means Indian, Nyaya means legal, Sanhita means code. So it is Indian Legal Code. Bharatiya Nagarik Suraksha Sanhita. Bharatiya means Indian, Nagarik means citizen, Suraksha means safety or protection, Sanhita means code. So it is Indian Citizens Protection Code. And Bharatiya Sakshya Adhiniyam. Bharatiya means Indian, Sakshya evidence, Adhiniyam means act. So it is Indian Evidence Act. The new legislations keep most of the old provisions but also introduced some changes. Let's see some of the changes introduced by these legislations. First of all, minor offences can now be punished with community service. Community service means a selfless work for the benefit of a particular society or for a noble cause. For example, cleaning a public toilet, planting a tree, etc. This kind of a punishment is a rehabilitative approach to justice and also aim to lessen the prison overcrowding. Secondly, if the police is conducting a search or taking possession of any property from the search, then the same has to be recorded in any electronic device like mobile phone, and immediately without delay they have to forward this video to the district magistrate. Thirdly, person can lodge criminal complaint online without there being any need to physically visit a police station. Fourthly, zero FIR. This means a person can lodge a complaint on any police station without looking into the jurisdictional issues. The police will lodge an FIR and then they will transfer this FIR to the concerned police station. Earlier, police used to reject FIR stating that the offences does not fall under their jurisdiction. Now, the police cannot reject such kind of FIR and it is their duty to transfer it to the concerned police station for investigation purpose. Fifthly, the police need to give the FIR copy, charge sheet copy, any statements, police report to the victim as well as to the accused within 14 days of filing. Sixthly, digital evidence, electronic evidence are now admissible as evidence in court just like paper records. Seventhly, women, person with disabilities, person with serious illness, senior citizens above 60 years, children below the age of 15 years, they need not visit police station and they'll get their assistance at their residence. Eighthly, the court notices, summons, which require the attendance of a person in the court, they were all sent by post. However, now the summons can be served through digital communication like WhatsApp, email, etc. This is an efficient and speedy process and also minimize paperwork. It is important to note herein that old provisions of Indian Penal Code, Code of Criminal Procedure, Indian Evidence Act will continue to be used in court for offences committed before July 1st, 2024. And for offences committed after July 1st, 2024, the new legislations will apply. These are some of the changes introduced by the new legislations. We will see in our upcoming episodes in detail as to each of these legislations. Thank you.
Thank you for watching. Stay tuned.